Good morning. Is it Mr. Alcock?
Yes, Your Honor.
Good morning.
Good morning. May it please the Court? My name is Edmund Alcock, and I represent the Seaport at Marina Bay Condominium Trust, as well as the Chapman's Reach Condominium Trust. I respectfully submit that this Court should exercise its extraordinary superintendent's powers in this case for four primary reasons. The first reason being that the condominiums have been denied access to the appeals court in the appellate process by the land court's two decisions striking two notices of appeals filed by the condominiums.
If we reinstate your notices of appeal, then after the case is tried on the issue of standing, you can obtain full appellate review of the standing issue plus anything else. Am I right?
Yes, Your Honor. You are correct. Once the case is tried, we would be able to obtain appellate review on whatever issue is tried.
Right, and including standing.
Yes, yes, absolutely. The issue, as I see it, is that presently we have a record and we have a decision from the land court that, in my opinion, establishes that we've already won the case if you actually square the land court judge's decision with the proper interpretation of Butler and Marashland.
Well, maybe, but no final judgment's been entered, correct?
Absolutely, Your Honor.
So you get
Are you suggesting that because you think on the merits you've won the case, you've won standing as far as you know, and you look at what the judge said in terms of your view of the substantive issue, do you think that, and putting the appeals issues aside for a minute, but do you think that we should recognize this doctrine of present execution every time an appellant, a party thinks, in my view, I've won this case, why should I have to go through a trial?
No, Your Honor. The reason that I respectfully submit that present execution should be recognized is because this Court's prior decisions, namely the Deerskin and the Bacon case, indicate that following a trial on the merits, a party cannot seek to have leave to review the denial of the summary judgment decision. And furthermore, I think the issue is, and I know that it's been briefed on the other side, and I think Judge Piper raised it in his decision, I'm not suggesting, and I don't think there would be any suggestion, that there would be any sort of clogging of the courts because a party files a present execution appeal, because if you look at the rules of appellate procedure, particularly Mass Rule Appellate Procedure 9E, when a present execution or any appeal is claimed by a party, the opposing party can file a motion with the appeals court, or the appeals court sua sponte can dismiss that appeal for reasons of substance even before the record has been assembled. So I guess to answer your question, I'm not suggesting that every time a summary judgment denial is made that it automatically creates a present execution issue, especially where there may be issues of material fact. Here, there are no issues of material fact. Here, I respectfully submit that the land court judge made certain findings both on the merits and as to the issue of standing, which if squared with the applicable case law properly, would have rendered a decision in favor of the condominium boards, both as to standing and quite frankly, as to the issue on the merits.
Now, once you file your notice of appeal, just refresh my recollection about this. The case proceeds, right?
Correct.
All right, unless you get a stay.
Correct.
So the case would proceed, and I take it that you never had you didn't seek a stay from the. I assume you wouldn't have gotten a stay from the trial court.
Well, that's correct. I mean, Your Honor, what we did was we actually filed the present execution notice of appeal together with a motion for reconsideration, right, asking the judge to reconsider Butler and Marashland, and the judge took it upon himself to sua sponte strike that first notice of appeal that we claimed under the doctrine of present execution.
And your argument is, in essence, that this case presents some unique circumstances under which that doctrine might apply.
Absolutely. And obviously, on top of it, the procedural issue being that this judge doesn't have the ability to make a substantive determination as to whether the appeal should actually proceed to the appeals court. As I think Judge Kaplan said in the Rudders case, substantive issues are for appellate courts to decide. Procedural issues, such as failure to timely docket and so forth under 10C, are for trial courts to decide.
So your position is you file a notice of appeal, it goes up to the appeals court. If the appeals court decides that the appeal has been improperly taken, it dismisses.
Correct. Correct. Absolutely. Under Mass Rule Appellate Procedure 9E, the appeals court could sua sponte say, well, no, sorry, present execution doesn't apply. In fact, the opposing party could file a motion even before the record has been assembled.
Asking the appeals court to dismiss it.
Asking the appeals court to say present execution doesn't apply, and then the appeals court could do that. Here, we didn't even get that chance because the trial court actually prevented us in both instances from even getting to that point and actually instructing the land court recorder not to assemble the record on appeal, and therefore hampering any ability to actually take the appeal. And I respectfully submit that the issue of a party's ability to test an issue on appeal, whether it's correct or not, whether present execution applies or it doesn't, is a fundamental right, and it's...
Where's the present execution? What is presently executed?
Well, Your Honor, the issue is, as I view it, is under Deerskin, under Bacon, I cannot appeal the denial of the summary judgment following a trial on the issue of standing.
Well, neither can anybody else, for that matter. So why are you so special?
Well, Your Honor, I don't suggest that I'm special, but I suggest that it's a situation where the present execution doctrine would apply because it's a right that cannot be remedied following a trial.
Be remedied. If there is a trial on it and you're found to have standing, then everything is fine. If there's
Correct.
a trial and you're found not to have standing, that can be addressed on the full appeal.
Well, Your
once
Honor,
your notice of appeal is reinstated.
but the problem...
And we do that every day in a bunch of other cases, so I don't see why you're so special.
The problem from my perspective there is first of all, you could clearly have a different record. You could have a record on appeal that is far different, after trial, that is far different than what is presented at the summary judgment level. Furthermore, I think...
I understand that. Mr. Alcock, why does that make a difference?
Well, it makes a difference in this case because, well, there's several reasons. I think the client or the condominiums will be faced with a different standard on appeal in terms of denial of a summary judgment versus the issue of whether or not standing was proved or disproved after a trial. I think it's different in this case because clearly we have a land court judge who is clearly misinterpreting the standard, the term credible evidence as used in Marashallin, as used in Butler, and even more recently as used by this court in Jepson. And I think, quite frankly, we have a situation where the two condominiums are going to have to go back to the trial court, try an issue on something where, quite frankly, I would suggest it's not even a triable issue. It's, you know, if you read Butler and Marashallin and even Jepson, all the credible evidence term is, it's a burden of production. And this judge is going to be requiring a actual trial on the merits using, assessing credibility of experts, determining and using a burden of persuasion on a burden of production. And I respectfully submit that it's not in the administration of justice to allow the case to go back and to be tried on something which isn't a triable issue to begin with, where the judge is clearly applying the wrong standard of law. And that's where I would respectfully submit it's out of the ordinary, it's out of the usual. When the cases talk about summary judgment denials and maybe perhaps non-applicability of of being able to test those issues after a trial. I think what the courts were really thinking about in Deerskin is we're not going to have appellate courts decide, you know, is this fact disputed, is that fact disputed? Here, we've actually established under proper application of the law that we should have won the case on the merits. Thank you.
Thank you, Mr. Olkoff. Mr. Brooks?
Thank you. My name is Peter Brooks. I represent 260 Victory Road. This case was scheduled for trial on October 9th, and that case was continued because of this pending review under 211 Section 3. But for the efforts of the plaintiffs here to obtain appellate review of an order denying summary judgment, the case would have been tried by now. We might well have had a
Was there a stay entered?
There was, yes.
Okay.
There was a motion for stay, which the court allowed.
This is just recently.
Yes. Well, it's what put off the October 9th
Right.
trial. So, yes, recently. But my point is, we already would have been through trial. We might have had a decision of the land court on the merits.
No, I understand. I mean, of course, you know, when people pursue appellate rights, it sometimes delays proceedings. But are you saying this is a frivolous appeal?
I am. Absolutely. The argument that the denial of a summary judgment motion brings out the present execution doctrine, I think, is completely frivolous. I don't think their summary judgment is any different from any other summary judgment. They think that they should have won below. They think they're being put to the burden of a trial unnecessarily. There's nothing that's presently executable below.
If their notice of appeal is reinstated, because it's been struck twice, then the issue of standing, if it goes against them, can be addressed from an appeal from the final judgment, right?
Absolutely.
But what do we do with the stay in between?
Which stay is that?
Well, if the notice of appeal is reinstated, what happens?
It'll go back to the appeals
Back
court.
to trial.
No, wait, no, it goes back to the appeals
It'll go back
court.
to the appeals court, and the
there'll be
appeals...
an appeal on the merits, right?
Correct. Or the appeals court will dismiss it, finding that the present execution doctrine is not.
But meanwhile, the stay is in effect,
Correct.
So it's another delay.
Right, and it could be a year or more in the appeals court.
Well, there's another alternative. I mean, if assuming we disagree with your brother, if we reinstate the notice of appeal and find explicitly the present execution doesn't apply, then it goes back to the trial court for trial.
Correct. That's right. What they're asking for is that this go back to the appeals court, and that the appeals court...
Decide on the merits of the present execution. And
What kind of an appeal are they entitled to in the appeals court? Is it a direct appeal? Are they entitled, or do they have to go through Chapter 231, Section 118 and seek application for
Well, they've already done that, and that's been
Turned
denied.
down.
They've gone to a single justice twice and asked for reconsideration of a single justice,
And that's been all turned down.
and it's all been turned down.
So that would be a panel appeal.
Right, right. And that's what they're asking for. And my concern is the delay and the disruption in the lower court that's inherent in allowing an interlocutory appeal, which was what they're asking for here. And there's no rights that they lose by going through trial. Like you said.
what's the evidence that should be, let's assume it's a burden of persuasion, not a burden of, what's the evidence?
Well, this is a traffic case. At its core, it's an issue between traffic experts as to whether or not our condominium project is going to have an adverse impact on traffic around our butters. We have an expert...
So there's a standing issue, right?
That's right. The issue is whether they are going to be affected.
There's dueling experts, and the judge is saying, and they say he's saying it wrongly, look, I got to listen to these two people before I decide the traffic issue. Correct?
Absolutely.
And if he decides in your favor, then he's going to throw them out with no standing. And if he decides in their favor, then they'll be heard on the merits.
Oh, the merits have already been
But then he
decided.
will have decided the
The
merits.
merits have already been decided.
Well, no, he
they
hasn't.
haven't.
No, he hasn't decided the merits.
No, but at the trial he will.
Well, at the trial he
At the
will.
trial, he will.
I thought the
Yeah,
merits
so-
had been decided on summary judgment.
Absolutely not. No.
At the trial, the quote merits are whether there'll be an impact of traffic, correct?
Well, that's the standing issue.
That's the standing
The
issue.
ultimate merit concerns an interpretation of the local bylaw as to,
I thought summary judgment was granted to the other side on that.
No.
no.
Well, what did the judge
There was
decide?
dicta in the land court judge's decision that said, if I were to reach the merits, on this record before me today, he agrees with the plaintiffs that the special permit should not have been granted.
Oh, well, why isn't that summary judgment? I mean, why isn't it, in essence, summary judgment?
Because he's saying, is he not, that if he finds against him on standing, then the point on whether the bylaw is violated is moot.
Right. And he didn't say conclusively that the plaintiffs win on the underlying merits. He said, based on the present record, what I have before me, my interpretation of the
Present
bylaw.
record being a summary judgment record.
Correct.
That
What-
they
what
win.
hap- So,
That's what what he said is
If
based
they
on
have
this record.
standing, they win.
Right.
And so the only question is standing to be tried.
Well, I don't think he was that conclusive on the merits. What he was just doing is making
here's
it
my
up.
question, Mr. Wilkes. Let's say he's wrong on standing, that it's production, not persuasion. In other words, you know, in all of these cases, there are always people, you know, they're not always people, but there are a variety of people who say, I have the right to come in and challenge, you know, what this development that's going on here. And let's say that the judge ultimately decides that he has to be persuaded based on, quote, credible evidence, and decides that they have either way. No, let's see, he decides they haven't met their burden of persuasion, no standing. But meanwhile, we're proceeding to the merits of the case. What happens? Is there an interlocutory appeal from his decision that there's no standing?
No, there's not.
And he wouldn't proceed to the merits,
right.
would he? Because there's nobody there to challenge it.
That's right.
I mean, it would be in effect, assuming he's correct in his tentative view that the permit shouldn't have been granted, an illegal special permit, but unchallenged, it becomes valid.
Right. No one's harmed by it, is basically what happens. So the standing is the initial threshold issue that then gets you to consideration of the merits.
But it seems, I mean, one of the things that concerns me, and maybe this is the only way we have to do it, is the very point of delay, because these projects, every day of delay increases the cost. I mean, we can practically stipulate to that. So if we can't get a fast review of standing, let's assume that they don't have standing, right? Shouldn't we be able to tell people quickly, you don't have standing?
Yes, and actually it's common practice in the land court these days to try to have an expedited trial on the standing issue. Bifurcate the issues, have a short 1, 2, sometimes 3-day trial on standing, and get that issue resolved. That does happen. And sometimes you don't need to get to the
That
merits.
doesn't speed up the process, because the person who loses on that, if they're found not to have standing, is then going to appeal that.
Can they take an interlocutory appeal from that? Well, that's a final judgment.
That's final at that
That's a
point.
final judgment.
Delay is, I mean, that's a,
Delay is anywhere.
Unless there's more than one party.
Yeah.
I mean, in other words, if one party.
Delay is inherent.
I'm trying to think of what's the most efficient way to, I mean, standing is, you know, is that you've got to get over that threshold. You know, not you. Parties have to get over that threshold, and what we're trying to do is expedite these proceedings so that you don't have endless delays.
well, I mean, part of the problem is just the process in the land court these days in terms of processing cases. We've already been held up 3 years on this project. This complaint was filed in 2004. You know, so getting quicker trials and getting these issues resolved, but certainly having interlocutory appeals is not the way to expedite this process. To the contrary.
The Jepson case, which just came down about a week or two ago, was delayed forever for the same reasons.
Right. Well, I think this is an issue for the legislature, and I know there are proposals out there to
Court
address
management issues.
Right.
I mean, you know, the costs are real. I mean, it may be ultimately your client doesn't prevail, but if your client does prevail, then we've got huge delay costs.
Absolutely, and particularly with a changing real estate market, it could be a devastating impact,
Well,
you
it
know,
could
on
put
my
an end,
client.
essentially, it can put an end to a project.
Absolutely, absolutely. I think, you know, the only other issue I think we have to address here, which we really haven't touched upon, which is the whole 211 Section 3, you know, standard here.
No, we
which
know
is,
the standard very well.
You're right, I understand. But, I mean, there's no substantive right that they're losing here. So there's no basis for 211 Section 3, review. All of their rights are fully preserved, by a trial.
But only if the notices of appeal are reinstated.
No. If they're not, we're going to go to trial. The standing issue will be tried. And if the judge applies the incorrect standard, like they said he did on summary
Okay, no, I
judgment,
see what you mean.
it'll
Okay,
be fully
fine.
reviewed.
Yep.
Thank you.
Thank you, Mr. Brooks.
All right. Hear ye,